unique opportunity to hear from the judges themselves about how we can do our jobs better, what they're thinking about all these issues that we've been debating this morning. I'm going to plow ahead and ask the judges questions that, and there may be questions that they're not willing to answer about the state of the law. But I'm just I've got an agreement with the judges that they're not going to hold me in contempt if I press for answers on some of the more burning questions that are going on out there. Again, I don't want to burn our time with introductions, and we could with this group. So let me just try to give condensed introductions of each of the judges. Judge Mark Bernstein has been on our bench here in Philadelphia since 1987. Very well known for effectively and efficiently managing class actions, and I can tell you is very well respected by both sides of the bar in that regard. He also happens to have written the book on Pennsylvania evidence. Judge Scirica, to Judge Bernstein's left, is a judge of the Third Circuit Court of Appeals. Judge Scirica is going to be joining the Penn faculty, I understand, in July. Some lucky first years are going to be taught civil procedure next year by Judge Scirica.
If they don't change their mind before September.
They can opt out.
I'll remember that.
Judge Scirica also served as chair of the executive committee of the Judicial Conference. Judge Scheindlin, to Judge Scirica's left, is a of course needs no introduction, is a judge in the United States District Court in the Southern District of New York. Very well known, again, for her effective management of complex litigation. To Judge Scheindlin's left is Judge Highberger. Judge Highberger is a judge in the Complex Litigation Center in what we call Central Civil West, the Complex Litigation Center in LA. A very, very important court, and a court that's where the law is really being made. Judge Highberger was sharing with me just moments before the panel started the most recent statistics for the filings in LA, which shows no significant change. So let me begin, really harken back to the discussion we were having this morning, and let me focus on this question of case management and looking at the Barron case and the Dukes case and this trend toward a higher, more rigorous standard at the certification stage. Judge Scheindlin, let's start with you. How does that affect your management of a case?
Okay, the best thing he said in preparing for this, he said it's not a quiz, so we thank you all for that. Let me say that listening to the last couple panels, there's no doubt in my mind that we're going to have much more discovery, a much later class certification motion. We're going to have to get through experts, and no judge in their right mind is going to do this twice. I do have to make that point. We're not going to have a certification on some issues and leave the hard ones for later. We're not going to be giving notice twice. That's not going to happen because we want to outlive our cases. We want to survive. It's tough to do these cases. So I now see that there's no bifurcated discovery. We're not going to do discovery and the merits separately. I think that's over. It's going to require a full record to do this certification effort. Now, I don't think I have to make the findings of fact that were being called for before on competing experts. I have to have enough of a record, which probably means hearing from both sides' experts, to be able to say, having heard the plaintiff's expert, having heard that person cross-examined, having heard the defense expert attack the plaintiff's expert, I can say that they both can go to the jury, but there's enough reason to believe that a reasonable juror could find, based on the plaintiff's expert testimony, what they need to find. That is the common answer to the common question. So I have to hear that all, but I don't think I need to say, and I therefore find the plaintiff's expert more credible than the defendant's expert. I think that's a Seventh Amendment problem. I don't think I have to go there. I have to have enough of a record to be able to say that a reasonable juror could so find. But to do that, I agree that I'm going to have a hearing now. I'm going to probably have to have not a Daubert light, but a Daubert, Because again, I'm not doing this twice. I'm not going to do a Daubert light hearing pre-certification and then have rebriefing of all the Daubert issues again later. Again, the cost, the delay, and the survival of the judge are critical. So I didn't mean to talk too long, but I do think there's going to be a sea change in this certification effort. It's going to come later. The earliest practicable time is now at the end. So they can get rid of that phrase, because the earliest practicable time is at the close of discovery. And somebody said in the earlier panel, do you need to depose my CEO to get this done? Probably not, but who wants to reopen discovery? It's going to conclude all at the same time. We're going to have the certification. We're going to go right on to summary judgment. And if there's a 23F, there is, and we'll get to that in a minute. But that's the story from my perspective.
Judge Scirica, what do you think?
Well, I think both Dukes and Barons are major changes in class action jurisprudence. In 1982, the Falcone case said that courts had to conduct a rigorous analysis, but the Supreme Court never really defined what that rigorous analysis was. So we had a lot of years between Dukes and 1982 where some of the lower federal courts started to put some meat to that term, what a rigorous analysis means. The standard, of course, has always been abuse of discretion. But to get to that point, Dukes said, and this confirmed what had already happened in the Second Circuit and then the Third Circuit and a few other circuits as well, that judges, that these were not mere pleading matters, that those who were seeking certification had to come up with something more than say so, that a threshold showing was no longer permissible. And some circuits have even said that you had to make certain findings and conclusions in order to determine whether the Rule 23 requirements were complied with. And so the Supreme Court in Dukes hinted that a Daubert hearing may be indicated in these cases, and certainly made it clear that the plaintiffs had a certain burden at the certification stage. So I'll stop at this point and allow my colleagues to go ahead.
Judge Bernstein, you've been known to conduct a very rigorous analysis at class certification, and we who practiced before you know that it's not been at all unusual for you to entertain Daubert-like inquiries at the certification stage. What are your thoughts on the trend in the interpretation of the federal standard, and whether is it coming closer to what you've been doing for years, or do you see it as changing your view of the way you manage a certification hearing before you?
Well, I haven't read as many Supreme Court cases as I've read this past week for about 22 years. U.S. Supreme Court, that is, and I've learned a lot about the changes in the U.S. Supreme Court since last I read that many cases in 1 week, which would have been Black and Warren, Douglas and Marshall. But I started doing all the class actions in Philadelphia about 6 or 7 years ago and gave it up about 3 or 4 years ago. And so without any history of class action work, so I was starting from scratch. And in our case, probably unlike the federal cases, we would only have 1 or 2 plaintiffs, named plaintiffs. So it always seemed to me that a summary judgment motion was suitable at any time, because if these plaintiffs themselves don't have a case or only have a partial case, they're certainly not typical of a larger class. I also couldn't imagine doing it without a hearing. And it just intuitively seemed to me that Daubert applied, because I understand Daubert, or we call it Fry, to be, is this science or is this junk? Is this astronomy or is this astrology? And whether it's before a jury or before a judge, if it's junk science, it's inadmissible. So I've always thought that Daubert was applicable. And then I started out, because people told me this is what you do, with bifurcated discovery, and then I found myself in discovery court litigating whether or not this was merits or whether this was procedural for certification. And very quickly I said, forget it. All discovery is fair game. If you want to make an agreement, fine, but I'm not going to litigate that. It's permissible discovery. Go do it. What I have to do in state court is find whether a prima facie procedural class is manageable. And I think that takes a full hearing. I always have. And the question to me is, can this case be tried to a jury? And these procedural Supreme Court decisions seem to lose sight of the fact that the end result is trial, and I think in part that's because on class action litigation, the end result almost never is trial. But on some occasions, I'll wrap up with this, on some occasions I've asked counsel, not defense, because the defense answer is it's impossible, Judge, that's the whole problem, but plaintiff's counsel to give me jury verdict interrogatories. If you think this is a manageable, certifiable class, let me know what questions the jury can answer that are uniform throughout the whole class system. And on some occasions I've gotten them, and we've tried a couple of jury verdicts. And on other occasions, it became clear that this is not a certifiable class. If these nonsense questions are the ones that the jury have to ask in order for you to prove your case, have to answer.
Judge Highberger, in California, I know from practicing there that it's not unusual for class certification to be litigated on briefs. Maybe some declarations, both sides submitting declarations. Do you see that? Do you see that changing? Do you see that changing after Dukes?
I haven't seen the change yet. Maybe it will change. I have the benefit of the fact my wife, Carolyn Kuhl, is a judge and has also been in the same assignment complex for most of the last 12 years, although now she's our assistant presiding judge. I'm not aware of any judges using live evidentiary hearings where witnesses, expert or otherwise, testify at a class cert hearing. So we get a pile of papers. Our wage and hour law is such that it's very difficult for employers to fully comply with state law. It's peculiar to California. It doesn't have an analog in the other 49 states. So 2/3 of our class actions are wage and hour cases driven by the peculiarities of California law. So it's a little bit like trial by compurgation, where you get X number of declarations on the plaintiff's side and Z number of declarations on the defense side about whether they were or were not in compliance. And those tend to prove very little. It's an attempt at kind of merits emotional argument about whether there's really an underlying case. And of course we're told, no, you're not supposed to figure out the merits, and yet the bar keeps trying to argue the merits. That does not help us when people mutate a class cert hearing into an attempt to try the merits. To digress slightly, pleading challenges, we call them demurs, you'd call them motions to dismiss in most places, gain very little in the class action setting. So what you have is the discovery battles and then the class cert battles. We have about 72 class actions being filed in LA County. They're all assigned to my courthouse. I'm one of 6 courtrooms that does it, so I get about a dozen new class actions each month. We get a lot of settlements, and we're also taking by transfer settlements of the old inventory that was first filed with our colleagues who have fast-track cases in the Maine County Courthouse. So we get more settlements as a result of having 2 different flows of cases. We see lots of settlements. We review them. We don't see many objectors. Our class action cases filed in state court generally are not large enough to attract most objectors. Now, I had one for over $1 billion involving farmers and a question of the charges within the complicated farmer structure, and the legal fees alone were over $400 million, as I recollect, for the successful plaintiff's class counsel. That produced an objector, not surprisingly. But the norm is we get unopposed class settlements. In terms of contested class cert hearings, the interesting thing is we probably, each of the six of us, get no more than one a month, if that are contested. Because you can just tell by what I'm telling you statistically that although they're filed, they're settling out. We get a small percentage, maybe at this point, 5 to 10% of the new filings where we actually, after the case percolates and the defendant appears, or perhaps the defendant's judgment proof and doesn't appear, where we get requests to dismiss on an individual basis for a little no payment. We get some removals to federal court, half of which come back. If it gets removed to federal court and assigned to a judge who used to be in state court, they always find some way to remand it. If it gets sent to federal court and it goes to a judge who is a direct appointment to federal court, they tend to stay there for whatever reason. But the former state court judges in federal court always, oh, you know, you filed it on a Thursday, you should have filed it on a Tuesday, or the paper wasn't recycled, or whatever. So what we're mostly doing is managing discovery and trying to urge counsel to focus. I would say, in terms of the things that really get fought, because that's what's more important than the cases that sort of roll off the log and settle, is you do need a good trial plan. And maybe it's because Dukes v. Walmart sort of came along and upset the apple cart, and maybe it's because the bar wants to get a class cert granted, and then we'll worry about trial later on the theory it'll settle. I don't really have to worry about trial, because certainly the norm is if it's certified in a contested situation, settlement surely will follow, and that there's still fair reason to think that. They're not all that well considered in terms of trial plans. So some of the ones that have actually had to ripen to trial are the ones that finally confront you as a judge with the problems of how you're going to try the case. Because it got all that way without really rigorous analysis, dare I say it. It used to be that the 3 easy ways to be reversed in California State Court if you're a trial judge were sustain a demur without leave. That's like grant a motion to dismiss, grant summary judgment, or refuse to certify class. In our appellate structure, you get to directly appeal refusal to certify class. You have to take a writ to challenge the grant of a class. And so the norm has always been to certify class when it's contested. That's changed some, but that certainly was the kind of the no-brainer approach to which way you're supposed to lean.
Now I know why I'm losing those motions, right?
Can I just add a couple things based on what the judge just said? All of my class cert motions are opposed. In federal court in the Southern District, I have yet to have a plaintiff move and a defense lawyer say, sure, go right ahead and certify. That does not happen. They are all opposed, and everybody feels certification is the game. If there's certification, there's going to be a settlement. If there's no certification, the case is over. So that's where the action is, and they're all opposed. I also wanted to say that when I think about Dukes and the post-Dukes couple of years, as opposed to what I think is coming from Barron's, Dukes really, in the end, I'm not sure has gone, from my perspective, has made all that much difference, surprisingly. I've gone ahead and been able to certify several classes, one of which had a 23F appeal that was turned down, thankfully. So that may be an outlier case, given the facts, the enormity, the size, all the rest of it. It's not had that great an impact on me being able to certify. Barron's, on the other hand, I think is going to make a big difference. I think that's where this new focus on the expert discovery, the Daubert hearings, the Fuller record, the fact-finding, that Barron's, I think, is going to change practice.
Let's explore something that Steve Sussman raised this morning. How would you react? I don't want to make your pitch for you, Steve. You want to make it?
No.
This is the bifurcated approach where you do 23A.
Oh yeah, no, I already answered. I'm ahead of you. I'm sorry. I said no way am I going to do this twice. Life is too short. It would also make it difficult to deal with the 23F problem. I'm going to do it once. So this is one district court speaking, but there's no way I'm going to accept that proposal. It's double briefing. It's double expense. It's double delay. All these things cause delay. Every motion is a delay, right? And there's so many motions that you can make on the road to disposition. I'm not going to do class cert twice, with great respect, Steve. It was a great flyer, but you didn't think anybody was going to go for it. But it's a
way, let me ask Judge Scirica's view on this. It seems like it's a way to maybe balance so that you could get that concept of the most earliest practicable time.
He didn't hear the proposal this morning.
No, I heard about it over lunch, though, however.
Okay.
And I was on the Rules Committee when that was adopted. My formulation was rejected, which was when practicable. but the committee decided that the earliest practicable time, if you can pronounce that word, was the way to go. And what the Rules Committee anticipated what the Supreme Court did in Dukes. Eisen had been around for a long, long period of time. None of us thought that it made sense. We all thought that in many cases it was impossible to consider the class certification decision without looking at the claim, the elements of the claim. How are you going to prove this? Was it capable of class-wide proof? And to do that, there was an overlap of the merits often, and you ought to be able to look at that. And so in an attempt to move away from at least what all the lower courts and most of the lower courts had decided when looking at Eisen, we said trial judges ought to have some time. They ought, if they need discovery, they ought to be able to take it. They shouldn't feel rushed into making a decision. And that was the basis of that change. We also did away with the conditional certification for the same reason. Many trial courts don't realize this. We still get cases, at least in my circuit, that are conditionally certified or perhaps have the de facto effect of conditional certification. And the trial judge says, well, you know, if I'm wrong, I'll decertify later on. But part of the reason, or perhaps the principal reason for eliminating the conditional certification was to give a signal to the trial judge, take your time, take whatever discovery you think is necessary, make these decisions. Now, what changed the game? 23F changed the game entirely. The big cases that came down from the Supreme Court in the 90s, the blockbuster cases, were settlement classes, Amcam and Ortiz. What 23F did was that it brought the litigation classes before the courts of appeals and now the Supreme Court. And it seems to me that we're going to get more and more decisions from the Supreme Court that we never would have gotten without the interlocutory appeal. I quite agree with what both Shira and Mark Bill have said. We have jurisprudence in the Third Circuit. How will the case be tried? The trial judge ought to look at this and say, how am I going to try this case? I think the jury interrogatories is a good way of probing that and figuring out how you're going to do it. If I were still a trial judge, that would be the first question I would ask. How am I going to try this case? And we require trial plans in federal court, and it makes a lot of sense to do that in the class certification situation, when, not in every case, obviously, but when we think it is necessary.
Before we get to 23F, and by the way, let me say, yeah, go ahead, Steve.
In federal court, should the normal sequencing be summary judgment, then expert discovery, then Daubert motions, then class certification? Should that not be proposition? Should that not be the normal sequence of a complex civil case that's being brought as a class action? And is there anything wrong with that? Is there anything wrong with putting your dispositive motions before you have? There used to be some theory that you shouldn't do dispositive motions until you have class certification.
Right.
That's gone, I said.
We have a case in California that says plaintiffs may not do offensive dispositive motion practice. Fireside Bank is the name of our case, because in theory they get to sort of see first whether they're going to win and then go for class cert after they do quality control on the case. A defendant, though, can move for summary adjudication and waive their rights under Fireside Bank if they think by knocking off the individual plaintiff with no res judicata to the class, they're where they want to be as a practical matter. But that is a matter of California state due process jurisprudence. There's a certain underlying logic to it, though, because of the consequences to the class action defendant of having to sort of roll the dice before you know the breadth of the res judicata, good or ill.
How do you handle that, Judge Bernstein?
I'm confused by it. How can you take summary judgment before expert discovery? Doesn't the summary judgment motion depend on what the experts say?
Well, not always. I mean,
You may need the expert just to aggregate, extrapolate.
You frequently do expert discovery after summary judgment, don't you?
It's very fact specific. Some cases,
But-
the antitrust case that you've been involved with, securities cases, we do need the expert for the summary judgment stage. Other kinds of
forget about-
cases, you don't, because you've got to see if the plaintiff's claim can survive, the representative plaintiff. But
Forget
that's
about
a
the
different subject matter specific, I think.
The
I
proposition,
think
though, is that the class certification is the last event in those various events. I mean, regardless of the other order of the others.
It's an
You should
interesting
get the
question, but I
job.
generally do summary judgment at the last step of all. Everybody seems to want the certification up front. That's been my experience. I don't know about the other
And it
judges.
depends on whether you're attacking the individual claim or whether you're
Right.
gonna move for, whether you're gonna move for summary judgment on the class claim. Judge Bernstein, you were.
I don't think it makes any difference in an individual case. What we did, as we do in all cases, is have a case management conference and set deadlines for discovery, experts, dispositive motions, but they're deadlines. They're not time when you have to file them. And then we set a certification hearing. And then if it's certified, we have another case management hearing, conference, where we see how much more discovery anybody needs, and we do the exact same thing. The discovery deadline, motion deadline, expert report deadline, pretrial conference, and trial. So we treat them as two different cases. But to set a rule, actually, as I think about it, there have been some cases where summary judgment didn't need expert reports because it was just based on the claim as presented. Our deadlines are deadlines. We will not accept a summary judgment after this date.
But if you have a certified class, the summary judgment decision has binding effect that it wouldn't have for a class that's not yet certified. So there's a certain advantage for both sides in having the certification decision first. I think that's why typically we do it. It binds.
But at the time you do that, you've already had all your expert discoveries done, because you got to have the expert discovery for the class. I mean, you don't want to, as a plaintiff, I don't have to present expert reports twice.
No.
I'm going to just do one.
Yes.
It's good for trial, it's good for class too.
And it's good for summary judgment. It is one.
It's good for summary
Yeah,
judgment.
sure.
So, so that, again, my premise is that the class certification is probably going to come after everything else.
Yeah, the only place we're disagreeing is summary judgment versus certification. I think that's the only difference. Bob, did you have a question too?
Well,
Yeah.
I was going to say, I think the Burren case in some ways supports where Steve is going, because in that case, obviously what happened there is the court had actually decided beforehand that only one of those four theories could go forward, but the expert had already formed his opinion about the effect of the super competitive prices using all four theories. So under Steve's theory, presumably, or Steve's approach, you would have had the summary judgment. Summary judgment would have clarified, one, whether there was any case at all, and two, the expert, having seen what the court did with summary judgment and pared the case down, presumably could tailor the expert's testimony to the one claim that was remaining in the case. Very unusual for me
It's
to
not
support
unusual in
Steve.
California, you know this, Judge Highberger, for a defendant to want to bring summary judgment before certification, waiving their rights under Fireside Bank, and say, I think I can kill this case before I do all the certification stuff. And I think typically the courts in California allow.
We're certainly prepared to deal with it, and indeed, because so few defendants really fight the merits of these cases, that's the flag of the rare defendant who actually thinks that they didn't do wrong, because part of the underlying dynamic of all this is either due to scofflaw behavior of the business community and other defendants, or due to the complexities of our law. There's a lot of violation of consumer laws and other laws that otherwise is passing without cure, but for class actions. And so the statistical percentage of the time you see a defendant come up with the I'm innocent routine is a relatively small percentage of the whole. You get a lot of other arguments, but it doesn't tend to be the I'm innocent.
Judge Scheindlin, let's talk about Rule 23. How has, or 23F, pardon me. and the interlocutory appeal certification orders, how does that affect your management of cases, particularly in MDLs? Do you stand down for the 23F period? How do you handle it?
Yeah. Judge Scirica just gave us the upside of the 23F. It gets the issues to the higher court earlier, and maybe even Supreme Court review, and makes law that might never have been made because the cases would have settled post-certification in the past. We wouldn't have gotten the issue reviewed. However, from the trial court's perspective, this is a complete derailment. Respectfully, if they were decided quicker, that would help. But when the 23F is accepted, and if it starts taking 2 to 3 years, which some of mine take up there, this is not the best thing for moving a case forward, putting pressure on lawyers to think about settlement, stopping the whole process of discovery, because you're right, I stand down at that point. There's no point in expending any further judicial or lawyer resources when the case is now in the Court of Appeals, essentially. So it's a game stopper. If they take it, it's over. Now, in the period between the application and whether they'll take it or not, then I'll keep going in the hopes that maybe we'll get something accomplished while the request is pending. And as I said, in a recent case of mine, that was great because they didn't take it and we'd move forward in the 6 months it took them to say no, or 9 months. It was a huge amount of time just to say no. It wasn't your circuit, of course, but it was a long time just to say no. But so 23 obviously has a pro and a con. It is a good thing for review of legal issues. It's a bad thing for case management. It does cause real delay.
We've had cases settled during the pendency of
I'm
the
sure.
23.
I'm sure.
Any other comments, Judge Scirica, on the 23F question?
No, and I think the Rules Committee thought that that in these class suits, the certification decision is the pivotal moment, whether it's a denial or the grant, and that courts of appeals ought to have the opportunity to decide whether to hear it or not. Obviously, it's highly discretionary. It's pretty much like a cert decision. And it can be criticized for being essentially standardless. But it seemed to the rules folks that it made sense. And we permitted interlocutory appeals in other areas, not to the same extent, perhaps. But that's why it was adopted.
So are we allowed to ask what is the standard? In other words, why do you accept some and not others personally? But what are you looking for when you say, I'll take it or I won't take it?
Well, the first time you read the petition and the answer, I mean, you think, is it going to make a difference? Has a mistake been made here? And we see them both ways, either the grant or the denial of class certification. And if you think there's some meat there, then you really dig into it and put your law clerk on it and come up with a very extensive memo. In the Third Circuit, we exchange memos on them. And we make that decision.
So one follow-up question. Should the lawyers take heart from a denial that you don't think there's been an error here? Because you just articulated you look for a real error if you deny the 23F.
Well, in the certification decision, absolutely.
Do you think so? That they should then read the tea leaves?
Yeah, but that's not the merits.
No. I'm talking about certification. They should not think they're going to get a good shot on certification issues on appeal.
You know, it at least in my circuit, the panels don't hold on to these. No. So you may go before 3 other judges who may have a different view of it. And so we just, given our responsibility and role to make a decision on the certification decision, we do the best we can, and then the case goes back.
Judge Bernstein, Judge Highberger, what's this? I mean, typically, I know in California, many cert orders are taken up on writ. Is it typical in Pennsylvania that those orders get reviewed as well? And what's your experience in managing that period when your certification order or denial is under review?
A denial of certification is immediately appealable. A grant of certification is not appealable, but we do have a system where I can certify that this is an important issue that there's significant disagreement about, and I can ask the Superior Court to take a look at it, and they never do. But I have asked a couple of times. Yes, and with respect to charging forward, if I think it should be reviewed or it's worthy of review, I won't charge forward. The attorneys also have the right to ask me, and if I say no, they have a right to file asking the Superior Court to look at it, and then I won't stop, because my guess is 1 out of 100 they'll look at.
Judge Highberger?
So similar to Pennsylvania, if we deny class cert, it's immediately appealable. And if we don't technically lose jurisdiction to deal with the remaining individual claim, it'd be idiotic to proceed with the individual claim, so we stay it. And that takes a while. I mean, our appellate process, best case is for a preference case 12 months and can be 2 years quite easily, assuming it doesn't go to the state Supreme Court. If we grant a motion to compel arbitration on an individual-only basis, that order is in theory not immediately appealable, but you can take a writ. But sophisticated plaintiffs' lawyers also argue that it's a death knell to the class action, and half the appellate panels view it as a death knell and take it as a direct appeal, and the other half seem to accept the writ as worthy of consideration, although that's a discretionary decision to take it through the front door. And so they'll deal with those cases about 95% of the time when they get a individual-only arbitration order. If we refuse to compel arbitration, interestingly, you can automatically appeal that order. So frankly, from the point of view of the gamesmanship of litigation, dare I say it, if you have a purported arbitration agreement, no matter how offensive, adhesive, 6-point type, signed after they whipped you or whatever, and you can't get it enforced, you still file a notice of appeal, and you have an automatic appeal. Trial court loses jurisdiction during the pendency of the appeal, and you'd be lucky to get that in and out of the Court of Appeal in 12 months. And it's more likely going to take 2 years if you have refused to order arbitration. So there's a real stick in the spokes to slow down litigation. So back to motions for class cert. If you order class cert, that is not appealable. If the aggrieved party doesn't like it, they can take a writ. They don't get entertained on their merits very often, maybe 10% of the time if that. And I, at least as a judge, if I find a case worthy of certifying for class action, I'm not sure why I'm going to also certify it for a writ to second guess my exercise of discretion, because I should have exercised my discretion better in the first instance so that I don't have to certify it for immediate review for the error I just committed in exercising discretion. So I tend not to certify those to go up on appeal. And our appellate jurisdiction is certainly falling in both directions now in terms of whether the grant or denial of a class cert is viewed as proper. We are in theory entitled to deference under an abuse of discretion standard as to reasons we articulate, though we have to articulate it. So if you're preparing an order in support of the grant or denial of class cert, it's important that you, as an advocate who prevailed on a motion, be sure that you get us to articulate all the good reasons why we went out the way we did, because we will not be reviewed with some kind of mercy for an alternative good argument that we didn't adopt, even if on appeal some bright appellate specialist thinks it sells the case. We have to be affirmed for the reasons we actually articulated.
Just a quick question. Does anybody know what percentage of the 23F requests are being granted? In other words, do you know how many you're taking percentage-wise? Or does anybody know statistically? No.
I'm pretty sure
It's
there are
about
national
30%.
figures on this.
Oh.
Rick?
It's about
30%.
it's about
30% are taken? Okay,
Yes.
thank you. That's helpful.
Judge Scirica, what about the standard of review? Has it changed effectively with Duke and Barron? I mean, this idea that you defer to the trial court's judgment about the certification. You look at the cases historically, there's a great deal of deference afforded to trial courts. Is that changing?
Well, if you look at Dukes and Barrons, the Supreme Court said that you have to affirmatively demonstrate compliance with the requirements of Rule 23. A party must be prepared to prove that these requirements are in fact met. And they were fleshing out the rigorous standard that they had adopted many, many years ago. So it seems to me, if I were a practitioner, I would take that to heart and put as much, make as strong as argument as I could that I'm able to do that.
Let me raise an issue about state and federal courts, competing, conflicting jurisdiction, overlapping cases. This is a unique opportunity to get your views and maybe, to the extent you're willing to share it, your practices let's assume Judge Scheindlin has these LCD television cases, the MDL on the antitrust claim, and she's got whatever 32 cases from all the states across the country, the ones that could be removed. Judge Bernstein, you've got before you an Attorney General action that's been filed in Pennsylvania seeking restitution for the people of Pennsylvania for paying too much money for the LCD TV. And Judge Highberger, you've got a case that was left in the CCW in LA for whatever reason, procedural default on the removal, whatever it was. And so
They got a local defendant, couldn't be removed.
Couldn't be removed, local controversy exception, whatever reason. Judge Scheindlin is working her way through discovery rulings, and she holds a hearing on a privilege question, and there's these key documents, and she makes a ruling, and a week later she finds out, that the lawyers in that case find out that Judge Bernstein disagreed as to 3 of the documents. Now they're getting produced. So we've got Judge Scheindlin trying to coordinate this litigation, and then we've got these cases in LA, and let's say the LA case is a purported nationwide class. Do you all talk when this comes up? Do you make phone calls? How does a phone call like that sound if it happens?
Well, the MDL judges are pretty well trained to do that. Whenever we have MDL meetings, they encourage us to reach out to state counterparts who have the same case. And we ask them up front in the first case management meeting, we ask the lawyers to identify state cases so we know who they are. We find out who the judges are. We try to get a conference call. But before I answer any more of that question or the other 2 judges, I thought it was quite funny that you only asked the appellate judge about the standard of review and whether it's deferential to the trial court. I thought you'd be dying to hear what a trial judge thought. We don't think it's all that deferential. Again, respectfully, I've been following the circuit opinions in the last few years. Frankly, I think they're very much leaning toward de novo. I do think they are looking at these class issues and saying, now, what would I do? Would I certify? Here's the evidence. What do I think? I don't think it's a very deferential review. I'd be curious what the crowd thinks. But I think it tends to be far more de novo than was anticipated, much less of abuse of discretion standard than one would have anticipated. I think the circuit court, and maybe it's the right thing because they're taking that certification issue very seriously and looking at the issues of law that are raised, and those are the ones, as you said, have also funneled up to the Supreme Court. Sometimes we couldn't have even anticipated. I was talking to one of the lawyers during the break, but my case from 10 or 15 years ago in the Second Circuit, the IPO cases, I had certified the circuit reversed, but very graciously, it was Judge Newman who wrote it, and he said, she wasn't wrong, she was following our standard at the time. We now change our law. We hereby today have changed our law. So she wasn't wrong, we want to issue a new standard. So, that was a long time ago, and that's when the Second Circuit anticipated the Supreme Court and really got into this rigorous review and the merits. Okay, fine, they made a change. But I'm just saying in general, I don't think it's a particularly deferential standard. I think if they take it for a reason. And that reason is basically, I would have done this differently. So, sorry about that, but I had to go back to that last question. On coordination, yes, we know how to make a conference call.
The one coming, it hasn't come across my desk, but I know my former colleague Victoria Cheney, now in our Court of Appeals, had the Vioxx cases, and there was a lot of that action, I think, a federal court in Atlantic City or some odd spot, or?
Federal court
state
in
court.
New Orleans and
Somewhere.
a state court in Atlantic City.
State court, anyway, so they were all talking, I know that, and we know how to make calls too.
Sure, it's quite right. The MDL panel encourages the MDL transferee judges to cooperate all the time with the state trial judges around the country, and there's been a real push in the last couple of years, and those who have handled these big cases, like Gulf oil spill or Vioxx, have done this, and they've related their experiences to the other MDL transferee judges. It only makes sense. Some of the judges did it way back, even in the 90s. Judge William did so in the Prudential settlement, where he had to coordinate with many suits that were filed around the country in state court as well. Yeah,
the PPA.
Absolutely, and there's their document depositories. Sometimes the federal and state trial judges sit on the bench together and decide discovery motions together. And Daubert motions or Fry motions, or they work it out. So they want to avoid duplication. They want to minimize the costs to the lawyers and the parties. And I think we'll just see more and more of this.
That's right. We've had joint hearings on many cases, many types of cases, even individual cases. The Meridian fire, we had a ton of federal court cases and a few state court cases. And we had joint discovery conferences and hearings, and recently there was a joint Daubert hearing. We're a Fry standard. Federal is a Daubert standard, and the evidence is all the same. And we had a joint hearing, and I'm sure every judge made their own decision, but it just happened they were the same.
Bob, again, did you have a?
No,
yeah.
I was just going to ask or comment, Judge Scheindlin, that, in favor of the proposition that there is some deference given to the district court judges. The statistic that 70% of the time,
Well,
right? So,
but that's not a
70%
deferential standard review. That's, I think, the ability to decide what are the standards for taking it. And I think we've got a candid answer here. You look to see if you think there's been error. So.
Well, the standard in most of the circuits was some form of threshold showing, which is not very well, depending on how you look at it. It is not what the Supreme Court thought was required under Rule 23 and the rigorous analysis standard. And the Second Circuit and then the Third Circuit articulated a standard saying, we may have done this in the past, but we think the rules require something more. And that's what Dukes and Barron's did, especially Dukes. It said, no, you do require something more.
Well, if the purpose for trial court deference is the trial court is in a better position to judge things. The trial court has to make the decisions on the spur of the moment. If you're not holding a hearing, if there's no credibility determination, if it's just on the papers at certification, the underlying reason for deference no longer exists, and the appellate court can look at the same material just the same as if it's a decision of law.
What I'm hearing is the experience is that when you've got these cases where you've got overlapping classes, that's something that you feel like the judiciary has relatively under control. You work together, and typically it works out okay. That's not a problem. Is that what I'm hearing?
Any responsible neutral has a huge moral obligation to avoid creating a kind of competing rush to judgment or rush to class cert. It would be scandalous. It's one thing if we're competing with a court in North Korea or something, but to compete with a court somewhere else within the United States on sort of, I'm going to get there quicker, when the bar should be forced to cooperate in as few forms as possible to maximize efficiency. It's the only way it should go.
And I think the MDL system has been beneficial that way because I have found that a number of my state court colleagues will say, well, since you have the federal MDL and you've got so many cases in it, actually I'm going to wait your ruling on that issue before I attack it. They'd like to hear from the federal court that has the MDL. So many cases, if I just had one, nobody'd be interested. It's just another judge of one case. But if you have the MDL, there is, at least I found some nice sense of let's not litigate this complicated issue twice. We don't have to follow you, but we may well, and we want to hear what you have to say. So the MDL system has been a benefit.
Yeah, in the 1990s, first filed rule was creating a lot of problems. And now the MDL panel, I served on that panel for a few years. When they make their decision as to whether to centralize and then where to centralize and which judge it goes to, they may consider matters such as how far along the case is, significant discovery has been established, the lawyers are working together well, those kinds of factors. But most of the time, most cases are not in that posture, and they do not follow the first filed rule when making that decision as to which court and which judge should receive it. And you all know that the ability and reputation of the judge means a great deal in the transfer decision.
But the biggest thing is to try to reduce the cost of discovery. Everybody writes about the enormous cost of discovery, especially in the electronic age. And so if we can have a single document repository, once the records are produced, they're available in all the actions, federal or state. Everybody can access it the same way. This is a great saving. So again, when we coordinate with fellow judges, that's one thing we want to be sure of, is not to duplicate the discovery efforts.
Everybody's got microphones, and this is your opportunity. So please don't be shy. Raise your hand. I'll acknowledge you. Let me ask. It may very well be that some or most of you won't be willing to share your thoughts on some of the more controversial issues because they may come before you. But what are any reactions, any thoughts about the Concepcion decision? This notion of individual arbitration. It's created such a transformative change for us in the practice of class actions. Does any of you have any thoughts you'd want to share about the wisdom of the decision or how it's being enforced?
If I taught legal method, I think I'd throw away what I was taught in 1972 and use some of these cases as a good way to teach a legal method, because the toing and froing in the jurisprudence, to me, is a great example of how you could teach first-year law students. Obviously, we all wait with interest to see what's going to happen with the American Express case, because I urge the bar in California, particularly the plaintiff's bar, focus on this argument under the FAA about effective vindication, because you don't have to worry about preemption of a state law argument if you will choose to tailor your argument to being a federally recognized argument under the federal statute. Of course, we wait to see what the answer to the question will be, and Professor Gillis, I guess, from her frontline report, is not optimistic that it's going to provide much effective vindication. So that remains unseen. It's fascinating in California because there's been so much turmoil in our appellate cases, and we have this particularly interesting nuance of these individually litigated claims on behalf of the public. And what are they? Are they individual claims subject to the contracts that the individuals make, or are they public claims delegated not to Ms. Hoffa and the Pennsylvania Attorney General, but to Mr. Sussman or somebody who's practicing law in California on behalf of the PAGA representative for the class, but do they nevertheless get cloaked in the public imprimatur and escape the apparent effect of the federal statute or not? So it's just a fascinating area, but as a sitting jurist, I think I'll leave it at that level of platitude.
One topic I would talk about briefly is, as the Supreme Court is less and less receptive to class actions, or is working harder and harder to cut back on them, are there alternatives for the bar that maybe achieve the same thing? So, for example, I had a case, big securities case, styled as a class action, turned it down. And so what the lawyers did as an alternative simply had joinder. We're seeing that more and more. Joinder, 50 parties. You know, it worked out fine. They just all came in as plaintiffs. They joined up. It did the same thing. Big issues were litigated across the board, and we avoided the whole class action problem. Of course, it didn't have the class-wide res judicata effect, but in every other way, it was an effective way for a lot of folks to litigate a big issue at once. So joinder, I think, is something you're going to see more of to get around some of the limitations being placed on class actions.
I see it as a dramatic expansion of federal power taking over states' rights. This is the Supreme Court, and it's astonishing which judges want to do it, who are saying that state determinations of what is or is not an unconscionable contract can be revoked by a federal law, which basically sets policy. The FAA basically says it's the policy to encourage arbitration, and then gives a little exception. And here's the Supreme Court saying Congress can reach into California and say you can't define what's an unconscionable contract if it involves the federal policy encouraging arbitration. So that's this state court's view.
Rick, any thoughts?
I'll change the topic a bit. I think one of the most interesting areas right now is the MDL practice, and particularly in the area of mass torts, and especially for mass torts that involve personal injury claims. It seems that the practitioners are unwilling to run the class action gauntlet because even if they can get a settlement, it might not approve because of commonality in law as well as facts. And so everything is piling into the MDL process where, and some people have even called it the quasi-class action process, where the courts have been creative and have exercised supervisory authority in terms of capping attorney's fees and doing some other things that have been called into question but may be perfectly proper. I'm not aware that there have been any federal appellate decisions one way or the other on these practices, but it certainly is a looser system. It has much less supervision, and the fairness of the settlements, the attorney's fees, the protection of the absent individuals and so forth, these are matters that just never come up for decision because they're not part of that MDL settlement process. And of course, you may or may not run into preclusion problems later on. So I don't know where that's heading. And a lot depends on what the practitioners want to do and where they want to take these kinds of cases in the future.
I'll change the subject one more time to a different topic that was alluded to. I'm not sure that Barron's versus Comcast applies in state court, and therefore whether you have to have a common answer on damages for class action in state court. But more generally, when you have a large class, whether it's consumer or employee or otherwise, there had been before Walmart v. Dukes a natural enthusiasm on the part of the defendants, especially to limit discovery to sampling. Keep the cost down, whether it was sampling on liability or certainly sampling on damages, but why not 5% of the whole or some statistically significant sample? At one level, empirically, it makes perfect sense. If you were a college professor or a government scientist trying to figure out patterns about weather or public health or whatever, sampling often is a perfectly rational way to get at things. We only promise people due process. We don't promise people perfect process. Sometimes you got to forget that the word due is sometimes a limiting factor on how much time you're going to get to be in the courtroom to argue about your rights. But obviously the defense bar is arguing that Walmart v. Dukes now means that everything has to be individualized. Not clear that that's going to be the end of the day when you try to balance due process versus that reading of Walmart, of whether or not sampling is still proper or not. But certainly when you're going into discovery, whether it's on a damages question as such that will then relate to the Barron's Comcast issue or just more generally on how you're going to tee up the trial plan at class cert hearing, it's important to have an informed and intelligent discussion between the court and the bar of whether or not you're going to use sampling for a good and sufficient reason, and if so, you're waiving the argument that somehow you have a right to individualized adjudication or not. Or get the defendant to commit right up front that they're buying the farm in terms of all this particularized discovery because they're going to insist later on their idea of due process at a highly individualized level and damn the cost.
I looked at a lot of post-Walmart cases, post-Dukes, and it depends if a policy is being challenged. If there's if you can point to a single policy or practice that's being challenged, then you may say, to prove that with a huge number of people, sampling would still work. I mean, if you've got 1 million people affected by a single policy, not individualized employment decisions of promotion or not promotion, but a policy, I think that we shouldn't say that sampling is out the window yet. That would be premature.
Professor Marcus.
Just to build on something Judge Highberger just mentioned and also invoke something Judge Scheindlin has encountered frequently. There is a counter pressure regarding this is all individual one by one that bites perhaps earlier, and that's preservation. If we have a proposed class action, does that mean that everything regarding every potential class member has got to be preserved now and forever because we're taking the individualistic cast? I suspect the world will not change that much. Whether that guess is right remains to be seen.
We had that issue in the Southern District. You remember the brouhaha between Judge Cott and then Judge McMahon in a wage and hour case? It was a big decision involving I don't think so, but it's the same. I'm sure we're talking about the same case. I can't remember the name right now, but it involved a big accounting firm as the defendant.
Yeah,
Right.
KPMG.
KPMG, exactly. And the problem was that KPMG wouldn't agree to a sampling.
Wouldn't allow anybody to
Right.
have access
To anything.
any laptop.
That's right. So because they wouldn't do any sampling that would inform a judge's decision as to what might be necessary to preserve, the district judge threw up her hands and said, I can't do a proportionality analysis without some evidence. And if you won't give me any evidence, then you're going to preserve everything. And so it was at that time not yet a certified wage and hour class, but she said everything had to be preserved, but she blamed them. She blamed
Well,
them.
I think this comes back to something Judge Highberger mentioned a moment ago, or a little more than that. The argument may increasingly be that the laptop of each of these class members will show whether this person was working 12 hours a day or 2 hours a day. And so you ought to keep everything on each one of them exactly the way it is today. Now, that's an overstatement of the kind of issue presented in this case that the judge described, but there are counter pressures against insisting on individualized treatment.
I just want to say KPMG is a fine firm.
No question, I did not mean to suggest otherwise.
Never looks at my laptop to see how much I worked every day. Judge Scheindlin, you just tried a class action case, which I know they don't try that often. Any lessons learned from the trial?
Yes, it was a fascinating trial, but it was also a B2, which it does make a difference. It was clearly a policy and practice case. Didn't have any of the individualized damages issues. There were 4.5 million stops at issue, and I enjoyed repeatedly saying during the trial that would be not just 1 or 2 of my lifetimes, but hundreds of my lifetimes if you try the facts of 4.5 million stops. You could never do it. So you are looking at a policy. Everybody used samplings. There were experts on both sides talking about sampling. It's been quite the experience, but as you know, since it's sub judice, I'm not going to say another word about it.
Is it the first stop and frisk class that's ever been certified?
You know what happens? Most of them end up in consent decrees, and as part of the consent decrees, they agree to the certification. So not only has there never been a trial that I can find, because I've been looking for precedents to help me, get to the decision part. There's none. They're all done by consent decree, which certifies the class. But the class mechanism almost doesn't matter all that much. It's injunctive relief. It's going to either approve a policy or not approve a policy. It's going to stop a practice or not stop a practice. So there's an enormous difference between B2 and B3 in this sense.
I'd throw in one random factoid. I had, for another panel back in March, queried all my colleagues in Los Angeles Superior. We serve 10.5 million people with 550 courtrooms now, down from 600 courtrooms. We do as much business as all of the Article III courts in the whole country. Because we're a single court for the County of LA, we're bigger than New York or Chicago's courts. But of all those cases in all our dockets, we only had, as best as I could tell, 8 class actions tried, basically since the history of all time and eternity, which is another way of saying for the last decade. About half of those were court trials, half of those were jury trials, and there seemed to be split outcomes between plaintiff and defendant. It was interesting, though, how many had been mutated into court trials.
After Kafka, so what kind of dippy cases, class cases, are left at state court?
In
we get
California, lots of them.
Yeah,
Well,
we saw.
Could you describe what they are? I mean, obviously, the federales don't trust you guys handling a class action. So what kind of cases are you handling?
We don't even think they changed after CAFA. We had a brief dip. This particular chart I had, I don't think reaches back far enough to. Actually, this was since CAFA passed. The flow went right back. Of the new docket cases I get, and 2/3 of all the cases I get are class actions. Of that, 2/3 are wage and hour. No employer manages to fully comply with California wage and hour laws. So they're just like sitting ducks. You employ people in California. Go home, buy your insurance, EPLI. If you're a small employer, you need EPLI, truly. But anyway, so 2/3 are wage and hour class actions under peculiar California law. The rest are consumer. My pomegranate juice had extract. It didn't have real juice. This Jillian Michaels thing that was supposed to make me thin didn't work. I had one involving lipstick or eyeliner that was supposed to make you thin because it shared a trade name with some kind of hyped up high caffeine product that was supposed to make you thin. And then we get a few securities cases. which tend to settle with disclosure-only settlements and then a fee award for plaintiff's counsel. We don't get any meaningful number of antitrust cases, and the securities cases are relatively rare and tend to all settle out. So we stay busy with wage and hour and consumer.
There may be a fair number of dippy cases, but the bar might also want to look, given the attitude of the federal top judiciary towards class actions generally, towards bringing 50 class action litigation cases in state court. One of those that I had tried to verdict, affirmed by our Supreme Court, was Kia Brakes, which wore out after every 5,000 miles. And jury trial awarded benefits, $600 per claimant, and a fair number of Pennsylvania claimants. It turned out to be a fair number of people. I had a Walmart forced to work off the time clock case, which was affirmed by the Superior Court, tried the verdict. It's now up before the Supreme Court. And that was every employee of Walmart in the state of Pennsylvania for a period of time. The Kia verdict, I think Kia settled in 48 states, and there's our case, there's one pending in New Jersey, and the verdict in our case was something, if not the same as the 48 case settlement, very close to it. Counsel may very well want to consider just doing 50 state class actions. Other than that, we do get a fair number of dippy ones, but they don't last that long.
Yeah, California, we're such a big economy and have some peculiar laws that are pro-plaintiff that it's a very natural venue to choose for the plaintiff's bar.
My favorite takeaway from this panel is the dippy case. That's one I'll use. And also Steve calling John's statue Kafka. That's the look on John's face.
Not the first time.
Thank you, judges. We appreciate your time. We hope you continue to join us.